A loud crash jolts you awake. Masked figures in tactical gear swarm your bedroom. Before you can react, plastic cuffs bite into your wrists. Your children are screaming. Is this a nightmare? A movie? No, this isn't fiction. This happened to dozens of families, including U.S. citizens, during a government raid in Chicago. Homes were ransacked, electronics seized, all without a single warrant shown. How could any of this be legal? We dissect the chilling facts of this operation, uncovering the complex legal tightrope walked and what it means for your rights. The clock is ticking on these fundamental protections. It began quietly, not in a courtroom, but within a Chicago apartment building. Residents experienced predictable rhythms, daily routines, a quiet sense of home. That fragile stability, cherished by families, shattered without warning, forever altering lives. This unexpected intrusion marked the beginning of a larger, disturbing narrative. It was early morning when doors splintered inward. Masked agents burst through, identifying themselves only as ICE. Families, including young children and confirmed U.S. citizens, were immediately zip-tied. Eyewitness accounts flooded online, detailing callous phrases uttered by agents during the raid. Homes were left in disarray, personal belongings, including electronics, confiscated. This aggressive seizure of private property and a disturbing treatment of families painted a picture of extreme overreach. The chilling reports sparked immediate public outcry and demands for accountability and answers. The crucial detail emerged. No warrants were displayed. Residents found themselves detained for hours, denied access to legal counsel. The immediate question exploded across online forums. How is what is happening in Chicago even slightly legal? This query became the focal point of a rapidly growing national debate. This post instantly captured widespread attention, not just for the raw outrage it expressed, but for fundamental legal questions. Lawyers, constitutional scholars, and concerned citizens scrolled through comments. They tried to make sense of what seemed, on its face, a blatant violation of rights, demanding immediate clarification. Initial reactions from legal professionals were stark. You suspect it is illegal because it is obvious that it is indeed. Yet the answer wasn't simple. Laws have layers, nuances exist. Grey areas can emerge, even in clear-cut cases, complicating what first appeared straightforward. A crucial distinction exists between the requirement for a warrant and the necessity of showing it during an operation. This subtle legal point profoundly impacts public perception and understanding. It quickly became clear that the case was far more intricate than initially assumed, prompting deeper scrutiny. The stakes were immediately clear. If such an operation could occur without transparent legal justification, what protections remain? This incident wasn't just about one building. It signaled potential erosion of foundational constitutional rights nationwide. The urgency was palpable. We needed to understand the legal landscape. How could this happen? Imagine an unexpected and forceful entry into a home. Individuals were removed from the premises, with family members present. This was not a fictional scenario, but a real occurrence. Discussions arose online regarding the legality of such events. This incident prompted a re-evaluation of common understandings. We're dissecting a Chicago apartment raid that left hundreds reeling, challenging bedrock constitutional protections. Our investigation will peel back layers of complex law, revealing surprising turns. The truth, as often happens, is far more intricate than it first appears, demanding careful legal analysis. The initial outcry focused on a seemingly obvious violation. No warrants were shown. It feels intuitive that law enforcement must present official authorization upon entering property. Yet, this initial point immediately led our analysis down a surprising path, challenging common perceptions of legal obligations. Legal experts clarified a critical, often misunderstood detail. No constitutional requirement exists for a detainee to be shown a warrant during its execution. This isn't about denying its existence, but the obligation to display it. This subtle distinction profoundly alters the immediate perception of individual rights. A warrant must exist, legally grounded in probable cause, approved by a judge, but officers aren't always obligated to display it instantly. This unexpected legal nuance immediately complicates the narrative. If warrants don't need to be shown, how do individuals verify legitimacy? What about the right to counsel? Again, common assumption collided with legal specifics. During a search warrant's execution, if merely detained, not questioned about a crime, there's no constitutional requirement for legal counsel upon request. Officers aren't obligated to stop or instantly provide an attorney while searching your home, challenging popular belief. These initial clarifications acted as a powerful pattern interrupt. They directly challenged widespread assumptions about our rights, creating immediate unease. If these aren't constitutional violations, the initial question sharpens: what is the actual legal battleground here? The inquiry shifted to deeper legal scrutiny. The real legal scrutiny, our analysis confirmed, centers squarely on the Fourth Amendment. This bedrock protection guards against unreasonable searches and seizures. The core question becomes, was this massive, coordinated operation truly reasonable under the law? Its sheer scale alone immediately raised significant red flags. Could a single warrant, if it existed, truly justify searching *150 separate dwellings? The overwhelming consensus from legal minds was highly improbable. This isn't just skepticism. It strikes at a core principle of probable cause, which demands specificity for individual units. Probable cause must be specific. It cannot function as a blanket authorization, allowing agents to sweep through an entire building without individual suspicion for each unit. Each apartment demands distinct justification. This makes a single, overarching warrant for 150 units profoundly problematic, undermining constitutional protections for residents. Then there was the description, masked agents with no identifying markings. This added a critical layer of concern. How are citizens, confronted by individuals breaching their doors, supposed to differentiate legitimate law enforcement from criminals? It's a terrifying question, eroding public trust and safety. This anonymity immediately highlights a profound breakdown of trust. It raises serious practical dangers for citizens who might reasonably believe they are under attack. It also creates perilous situations for legitimate agents, blurring lines that should be crystal clear, compromising safety and identification protocols. But officers don't always need a warrant for arrest or detention. Probable cause can suffice in certain circumstances, like catching someone mid-crime or with an immediate threat. These are fluid, reactive situations where swift action is necessary, often precluding the time for warrant acquisition. However, this Chicago operation was different. It was a systemic, pre-planned action, not a reactive hot pursuit. The sheer scale and coordinated nature fundamentally demand a warrant, or an exceptionally robust, publicly transparent justification for its absence. The stakes rise significantly, requiring higher scrutiny for such large-scale events. Could this entire operation be tied to broader executive orders? One terrifying theoretical emerged. Perhaps a declared hostilities against cartels could expand federal agents' powers. This chilling idea, raised by a legal expert, pondered the blurring of lines between civilian law enforcement and military authority, with profound implications. Such a declaration might, in theory, expand federal action, but civilian law enforcement powers cannot be unilaterally expanded by a presidential declaration of hostilities. This theory, though concerning, faces profound legal challenges. The president does not hold unilateral power to rewrite the Constitution, ensuring checks and balances remain. The fundamental tension between executive action and legislative oversight becomes immediately clear. Presidents simply cannot bypass Congress to grant agencies new, expansive powers that override existing constitutional protections. That's a critical check and balance, essential for maintaining democratic governance and preventing unchecked authority from arising. But the very discussion of such possibilities raises the stakes significantly. It pushes the boundaries of what is considered legally plausible, challenging American jurisprudence's framework. It forces us to confront uncomfortable hypotheticals about unchecked power, underscoring the constant need for vigilance against overreach. This raid wasn't just about individuals caught in a dragnet. It touched upon unalienable rights that should apply to everyone within the country's borders, citizen or not. These rights transcend status, intended to protect all persons from government overreach, a foundational principle of justice. Comments from legal professionals revealed profound helplessness. The powers that be simply don't give a FCK anymore, one lawyer wrote, expressing raw frustration. Another added, they violated many court orders with impunity. This sentiment highlighted a deeply unsettling perception of accountability failures. This sentiment represents a deeply unsettling lowest point. It embodies the fear that even clear legal violations might go unaddressed. It suggests legal challenges are often too slow, too weak, or simply ignored, fueling a dangerous perception of lawlessness from within the system, eroding trust. Another critical concern: can individuals even sue federal agents directly for civil rights violations? The legal landscape around suing agents, especially from agencies like ICE, is complex. Qualified protections are often in place, making this not a simple path to accountability, daunting for victims. This creates a significant barrier to justice. If individual agents are shielded, how can accountability truly be sought for those impacted by potentially unlawful actions? It leaves many feeling powerless, questioning the very mechanisms of redress and the overall fairness of the legal system itself. We consulted a constitutional law expert who emphasized, the Fourth Amendment doesn't vanish just because someone is undocumented. It protects people, not just citizens or those with certain immigration statuses. This is a vital reaffirmation of universal rights within U.S. borders, regardless of personal background. Documents authorizing agency actions were meticulously explored. For example, 28 U.S.C. Section 533(1) authorizes the Attorney General to detect and prosecute crimes against the United States. On its surface, this grants broad powers for federal investigations, appearing to justify wide-ranging actions by agencies. However, while granting broad investigative powers, this statute still presumes strict adherence to constitutional rights. This includes probable cause and the Fourth Amendment's warrant requirement, especially for large-scale operations impacting multiple residences. It is not an authorization for unbridled power, demanding specific legal grounds. The legal framework consistently demands precision and robust justification. It does not provide a carte blanche to raid an entire building, displacing and detaining inhabitants. The law sets clear boundaries, even when its application appears disturbingly opaque, ensuring fundamental protections are not ignored. The initial shock had faded. Disheartening reports were meticulously sifted. Now, from complex legal arguments, a decisive picture solidified. But it wasn't the picture many expected, revealing unexpected twists and turns in the interpretation of constitutional protections. The true battleground emerged. A crucial point emerged. Showing a warrant or providing immediate legal counsel during a raid is nuanced. Federal law, surprisingly, doesn't always mandate agents present a physical warrant on the spot, nor instantly provide lawyers to everyone detained without questioning. Yet, experts pointed to clear violations. The critical flaw, the real constitutional breach, wasn't about agents failing to display a document. It was deeper. The likely absence of any warrant, or one predicated on specific, individualized probable cause for each apartment. This systemic lack of justification became key. An operation conducted across an entire residential building, where occupants were subject to detention without specific suspicion for individual units, constitutes an unreasonable search and seizure. This comprehensive action, by its nature, appears to have operated outstanding established constitutional boundaries, raising concerns regarding compliance with the Fourth Amendment. This situation provided significant indications. But the story's true turning point wasn't a sudden court ruling. It was a ripple effect within the legal community. Online discussions, fueled by outrage and helplessness, ignited a different fuse. One lawyer, galvanized by injustice, declared, "The time is long past for lawyers to start standing up and fighting back." His words resonated deeply. This declaration marked a significant shift from passive observation to active resistance, inspiring many to reconsider their roles. The call to action quickly spread, promising a new phase of legal challenges against systemic abuses of power. This wasn't just rhetoric. Tangible action was announced: active recruitment of an immigration lawyer and a criminal defense lawyer. Their mission? To form an ICE defense group dedicated to a singular purpose: bringing civil lawsuits directly against the agents involved and their superiors, demanding accountability. This represents a tangible outcome, a direct, proactive response to initial despair. The path forward became clear: litigation. This means class action lawsuits, individual civil rights claims, a multi-pronged legal assault. The resolution won't be a single swift verdict, but arduous battles. It will be a series of arduous, determined legal battles, each one meticulously aimed at holding powerful federal agencies accountable, one violation at a time. This long-term strategy seeks to dismantle systemic issues, ensuring justice for those impacted and deterring future abuses. The legacy of this raid becomes more than an isolated incident. It transforms into a stark reminder of civil liberty's fragile nature, underscoring constant vigilance in protecting rights. While legal technicalities are complex, core principles of justice and constitutional protection remain non-negotiable, sparking action. This incident hasn't just exposed a problem, it has sparked a proactive legal movement. It demonstrates that even against seemingly insurmountable odds, the fight for fundamental rights can, and indeed must, begin. This ongoing struggle defines the essence of a vigilant citizenry. So, how could the Chicago raid even happen? How could federal agents, without warrants, zip-tie residents, including U.S. citizens and children, and ransack their homes? The explanations point to a confluence of deeply troubling factors that challenge the very foundation of legal protections. First, aggressive executive enforcement policies emerge, cloaked in national security rhetoric, emboldening agencies to push authority boundaries. Next, legal ambiguity around border zones extends hundreds of miles inland, like Chicago. This broad, ill-defined power becomes ripe for exploitation by officials. Perhaps most disturbing is a perceived sense among some officials, a belief they can act with impunity. They know legal challenges are costly, protracted. They know that even when sued, administrations have historically violated court orders, fostering a climate of perceived invincibility. So, where do we go from here? The fight, unequivocally, is not over. Organizations like the ACLU will be pivotal in challenging these actions. But the burden also falls on individual lawyers and advocates. They must step forward, demonstrating unwavering commitment to justice and civil liberties for all. For anyone facing such a situation, practical recommendations are crucial. First, know your rights. Second, do not resist physically. Critically, do not consent to searches. Demand legal counsel immediately. If safely possible, document everything: photos, videos, notes. Seek legal help the moment you are able, without delay. The moral of this story is clear. Laws, no matter how firmly enshrined, are only as strong as people's willingness to understand and defend them. This Chicago raid serves as a potent reminder. The pursuit of justice is not theoretical. It is an active, ongoing struggle demanding constant attention. It demands constant attention, sharp legal expertise, and unwavering collective resolve. This incident highlights that constitutional protections are not self-enforcing. They require a vigilant citizenry and a dedicated legal community to uphold them against overreach, ensuring liberty persists for everyone.